Any mention?
May it please your Lordship. Lordship, I beg to mention item number 4.
Yes.
Lordship, I pray for 2 weeks' time as the learned DSJ is indisposed.
Who is for the petitioner here?
Lordship M. Chanda. Sir
Where,
M.
is they? Where
Chanda.
are they? No one is there. Anyway, just you inform.
Lordship. I'll inform them, Lordship.
Okay, just appear meter on method. Majika. Learned DSJ APM with the respondent. List is matter after 2 weeks. Yes.
Lordship, similar prayer for item number 7 and 8, Lordship.
Who are there in 7 and 8? Yes, Mr. Jha. 7 and just on prayer minutes answer. No objection by Mr. Jha. 7 8. After 2 weeks. Yes.
Lordship, similar prayer for item number 10.
You can have it next week, my lord. This matter, the person is in custody.
Lordship, Tuesday.
She's asking for 1 week, I believe.
Lordship, 1 week.
This one. Dr. Majika also has some.
I'm not objecting, my lord. Just that next week, if he's there, my lord, we can have it.
Okay, just this is on prayer of answer after 1 week. Yes. Number 10.
Obliged.
May it please your Lordship.
Yes.
Lordship, I beg to make a mention of item number 5 and 6, your Lordship. They are similar matters, Lordship. I'm praying for 2 weeks' time on this matter.
Why?
Why? Lordship, senior counsel is having some personal difficulties, Lordship.
No objections.
On prayer made on view of Mr. Capel.
Obliged.
Not objected to by the learned counsel appearing for the state respondents. Just after 2 weeks. 5 and 6.
Obliged.
Grateful.
May I please, your Lordship, I beg to mention item number 14, Lordship.
Item?
14, Lordship. Up to 3 weeks, Lordship.
Yes.
I'm for the respondent number 3, Lordship. Up to 3 weeks, Lordship.
Why, this is criminal petition in what matter? Those POXO matters.
This is dispute between husband
Husband
and
and
wife.
wife.
The allegation that wife has stolen some documents.
Okay. Yes. Any objection?
No, your Lordship.
It's on prayer made. You are appearing for respond number?
3, Lordship.
On request made. On behalf of the respond number 3. By the council appearing on the respond number 3. This is matter after 3 weeks. Yes.
Highly obliged, Lordship.
Yes, Mr.
I'd
Sandhu.
like to mention, my lord, hearing number 12. It's a 482 matter, my lord. We have sought for quashing of the pending proceedings, POXO. We have taken a specific plea of consent. Now, during the course of the proceeding now, trial court, since there is not granted by the Supreme Court, during cross-examination, the mother has given a testimony that she has changed the age of her daughter. And now if we count that one, she has decreased 3 years. So if 3 years is added, it is more, she is more than, victim is more than 18 years. So if Lordship permits me to bring on record the deposition.
But the thing is that if that is happening before the trial court,
Yes.
why you want to short circuit the trial? Let the trial court take a call on that.
My lord,
See-
that will be a cumbersome procedure, my lord. If the evidence is revealed,
Trial is going on.
that is
Let
true.
it come to a logical conclusion.
But that will
You,
Lordship
see, you
is.
can bring it on record. There is no bar for that. But the thing is that how far this court will take cognizance of that will
My lord,
decide.
I'll try to.
That will remain separate.
My subject to Lordship
This
satisfaction.
court basically is not in favor of short circuiting the trial.
My
Short
lord,
circuiting.
we'll satisfy.
If something is revealed during the evidence stage, let a trial court take a call on that.
That is, Lordship only allow me to bring on record and Lordship may examine this aspect.
Okay, this item number 12.
Item number 12.
Yes. Yes, Mr. Sanjukta.
No objection to that.
Yes, it is submitted by Mr. H.L. Sangrai, Senior Counsel, appearing for the petitioners. the deposition recorded during the course of the trial of what this case? What that case?
My Lord, POCSO case number 1 of 2020.
During the course of during the what is it? Deposition recorded during the course of trial of POCSO case number so and so and so. Yes. Would be relevant for the purpose of consideration of the plea raised by the petitioner in this case. Stop. The London Council, Senior Counsel, therefore prays for permission to bring such a deposition, bring on record such deposition by way of additional affidavit. By way of an additional affidavit. Stop. Mr. Shangipta, Learned Counsel, Learned Additional Senior J. Penning for the state husband has no objection. Prayer allowed, list after 2 weeks.
2 weeks. Evening.
Supplementary cause list, item number 1.
Yes.
May I please, Your Lordship? Lordship, the petitioner herein is challenging the sentence order passed by the General Assam Rifle Court Martial, wherein previous occasion Your Lordship has granted us the liberty to withdraw the previous writ filed by the petitioner. The petitioner was on bail.
Yes. Okay.
Yes, Your Lordship.
Yes, yes. This appellate, the order of the appellate authority came later.
Yes, Your Lordship.
So that is the same thing.
That same thing.
challenge.
Yes.
Okay, we'll issue notice then. What is the period of sentence?
1 year, Your Lordship. 1 year and dismissal from service.
Oh, it is only dismissal from service.
Yes, Your Lordship.
Not an, this thing.
1 year sentence is also there. 1 year's imprisonment and dismissal from service.
So what about the sentence?
Sentence was suspended, Your Lordship.
It was granted.
He was granted bail.
Sentence
on
was
suspension.
suspended in the previous round.
Yes, Your Lordship.
And what about this present?
Lordship has granted liberty to file it afresh by granting bail to continue till the filing of the instant writ petition, fresh writ petition. The order,
So, okay. So then it means you are making a prayer for grant of fresh bail now.
Lordship, Your Lordship had granted liberty that I should
Where is the
file
order? Where is the order?
the order is at page 69, Lordship.
Yes, it was for 4 weeks to enable you to file
Yes,
a
sir.
petition.
So
So that means
within-
you have to take a fresh bail. It never, did not say, you see, the order is that it will continue for 4 weeks to enable the petitioner to file a fresh petition. And if you, in the event you fail, of course that is not here now.
Yes, sir.
To file, then the bail would stand cancelled. So in whatever thing, the bail is for a period of 4 weeks. So,
But as per the order of the bail, Lordship, if Your Lordship would kindly
bail of
suspension of the sentence. 67, Lordship.
that is an earlier round, isn't it? The interim order will merge with the final order.
Yes, Your Lordship. Then I may be allowed to file this case for in the meantime.
Now again, that will cause a technical difficulty. Now you have filed a writ petition already. Okay, 4 weeks.
Yes,
When 4 weeks expires?
26th of August, 26th of September, Lordship.
Today is what date?
Today is 17.
Okay, so you file this thing then,
Yes, Your Lordship.
application for grant of bail.
Yes, Your Lordship.
Yes,
Lordship, kindly allow us to seek instructions, Lordship.
definitely you have to file your affidavit also in the main case. What about prayer of bail? He's already on and is 1 year's thing, so court is inclined to grant him bail. There is no question of
And
yourself
moreover,
opposing
Lordship
it.
would appreciate that he has already undergone
That is
6
okay, but then
months
there has to be a formal.
Yes, Your
You
Lordship.
see, have you made any prayer in your writ petition?
No, Your Lordship. I'll file.
You do one thing,
Yes, Your Lordship.
file it. How long will it take to file?
by Friday only, Lordship, because since tomorrow it's a holiday, so.
Of course, this earlier bail will remain valid for 4 weeks, isn't it? Then we'll.
If your Lordship may kindly grant us another 2 weeks, then.
No, we cannot until unless you see. If you file an application, this court is inclined to grant you.
Yes, Your Lordship.
Okay, so this is we are considering the fact that you have been imprisoned only for 1 year.
Yes, Your Lordship.
Okay, but then there has to be a prayer, formal prayer for this, or you file an application. We do one thing, we'll list it on Monday.
Yes, Your Lordship.
Before that, you file, ensure that you're filing this case and get it listed.
Yes, yes.
We'll do that. That is better. You should not take him into custody. Make it clear to your clients. They should not do it. Anyway, just on prayer made by Mr. Joshi, Learned Counsel appealing for the petitioner. This is matter on. Just give him Monday's date. Do it. You see, this is. Otherwise, you will have to be taken into custody if you don't. Yes.
Deeply obliged.
Item number 2.
Yes, 1 minute. Yes.
Well, it's, I am before your lordships.
Before my friend starts, my lord,
Wait.
the revision, my lord, is barred by limitation, my lord. So
You are appearing for?
I'm a caveat, my lord, in this case.
There is a caveat.
Yes, I'm a caveat.
1 minute, Mr. Paul. Let us discharge.
Malus.
Yes. Caveat. Oh, there is caveat. Caveat 87. Caveat number 87 of 2025. Yes, Mr. Karim, Learned Counsel, representing the caveat, submits that a copy of the connected civil revision petition has been supplied to the caveator. Stop. The caveat as such stands discharged by allowing the caveator to oppose the motion of the civil revision petition. Yes.
Malus.
Yes, Mr. Paul.
Malus, coming to the objection of my learned friend,
Yes.
this application is filed. This application is filed under Article 227, Malus, of the Constitution. The reason why, Malus, it is filed under that is, and I'll just narrate why, Malus, we maintained it under Article 227 is. Malus, I'll just give your lordships a brief backdrop as to what has happened in this matter. Malus, I had filed a suit registered as TS number 4 of 2018.
Mr. Paul, the thing is that your petition says is under 227, read with section 36A. Now
It's read
that
with,
is what the
Malus.
problem is.
Malus, the primary provision would be 227. Malus, 36A is only for the purposes
No,
of
that
saying,
is,
Malus.
that is, you see, one thing very difficult. This court finds it difficult. You see, if two provisions
Malus.
does not contain the similar proposition, similar law, then it becomes always become difficult. And
Malus, if your lordships are, Malus, if I can assist your lordships on this, Malus, because when we say, Malus, an application is filed under 227 read with any other provision, Malus, that is only supplemental to the original provision. So it would essentially be under 227 only, Malus.
now which your 227 gets supplemented by provision of 36A.
Malus, because it is the supervisory jurisdiction.
See, the constitutional provision stands at a higher pedestal. It is always
Absolutely, Malus, absolutely.
And you
absolutely. That's
invoke
the
it,
source of power.
You invoke it only in exceptional situation, not in general situation. It cannot
Absolutely,
replace the
Malus.
general
I
power
was
of
coming.
revision.
I am coming to that only, Malus, why we have filed it under 227. Normally, it would have been under 36A, Malus, but here there are reasons why it is filed under 227. Because if I'm under 227 before Lordships, Malus, I would be on a short compass. I'm conscious of that fact.
Yes. Just tell
Malus,
us.
Malus, the limited issue here is, if I can come straight, Malus, is that the learned trial court, Malus, is dealing, the learned first appellate court, Malus, is dealing with an appeal arising out from an injunction application. I had filed a suit, Malus, there is an injunction in my favor, the injunction is made absolute. Against that, Malus,
You sit down, please. Yes.
against the making of, Malus, against the order making the interim injunction absolute, an appeal was filed. That is the factual matrix on which we are. In that appeal, Malus, while deciding the matter, the learned First Appellate Court, my lords, frames an issue coming to a finding, my lords, that there is an earlier suit. Admittedly, no Section 10 application is filed in that suit or in this suit by the respondents. And, my lords, a question is framed, and I'll just point out at page 175, if my lords kindly quickly have a glance. It says, my lords, third point for decision, whether title suit number 4 of
which page you are reading?
Page 175, my lords.
Now, the factual aspect is that you file a suit along with an application for grant of injunction.
Lordship.
Injunction is granted in your favor and it was subsequently made absolute.
Correct, my lords.
Yes. Now, whether a written statement or objection was filed by the...
Not filed.
Okay. So, no plea was taken by them before the trial court.
Nothing, my lords. It is on record.
Against the order of injunction,
they go and file an appeal.
Yes. Okay. Okay. Now,
I'm sorry, my lords.
The appellate court has interfered with the order of injunction. That is how you are here.
I am here.
So
and how does it interfere, my lords? It says that there is another suit.
You are referring to page
175. 175. If my lords quickly have a look at 175.
Yes.
My lords, point number 3, if my lords kindly have a look. Third point of decision.
Yes.
Whether the title suit number 4 of 2018 and miscase number 3 of 2018 ought to be stayed under section 10 CPC. If so, whether this court can suo moto stay the subsequent suit.
Okay.
So, my lords, in the absence of any application, in the absence of any written statement or show cause, the learned trial court, my lords, without having the records of the other case before it, frames this question and it answers it, my lords. The answer your lordship will find at the next page.
Section 10 is coming, there is a parallel suit pending.
My lords, in the appeal, they brought out a case that there is another suit which is pending. In the appeal.
Yes.
And, my lords, the question therefore was, assuming, my lords, there is another suit for the sake of argument, which is in relation to the same plot of land between the same parties, then somebody would have had to file an application, my lords, under section 10 for stay of the suit.
Definitely.
Not filed.
Yes, that is a question question of law and fact, isn't it?
Absolutely, my lords, which is why I am here before your lordships under 227, because the learned appellate court says, can suo moto I do it? And my lords goes on to suo moto stay the proceedings.
And which way it justifies its suo moto action? Is there any...
My lords, I'll take your lordships to the next page, page 176. My lords, may kindly have a look at 176.
Yes.
May I read, my lords, the last paragraph of 176?
Yes, please.
Now it is for this court to weigh as to whether the conditions are fulfilled or not, so as to come to a conclusion that the subsequent suit ought to be stayed. From what has already been discussed in point number 2, it is seen that there are two suits, that title suit number 5, which was previously instituted, and title suit number 4 of 18, which was subsequently instituted. And it can be said that the matter in issue in the subsequent suit is directly and substantially in issue in the previous suit. It is also observed that the parties in both suits are the same and litigating under the same title in both the suits, that is declaration of right, title and interest and permanent injunction. It is further observed that both the suits are pending before two competent civil courts of original jurisdiction, and both the courts presides at East Gentiles District Cleriac within the judgeship of this court. And the trial court before which the previously instituted suit is pending has the jurisdiction to grant relief sought for. Most significantly, what is observed by this court is the subject matter of title suit number so-and-so is directly and substantially an issue in the previously instituted title suit number so-and-so. Then, my lords, the judgment is recorded at 177 and 178. My lords,
it is not on section 10. What we want to know is that which way it justifies its suo moto action on section 10.
It does not, my lords. That is what I am trying to submit before your lordships. It does not. It refers to a judgment at 177 and comes to 178. My lords, may kindly have a look at 178.
Does it result into wrong exercise of jurisdiction, or it is
my lords,
wrong assumption of jurisdiction?
It is wrong assumption of jurisdiction, my lords. It is usurpation of jurisdiction.
No, but
It
then
usurps jurisdiction within
otherwise,
that, my
this
lords.
court had the court was was otherwise authorized to deal with the appeal.
No, my lords. No,
Yes,
my lords.
hampered.
Court was authorized to deal with the appeal.
Yes.
I bow down. Yes, my lords. But in appeal, when, my lords, there is no finding of, my lords, any
Where is
earlier suit.
what are the ground taken in their memo of appeal? Can we see?
I can take your lordships to the memo of appeal, my lords.
Now, what happens, Mr. Paul, when a
My lords.
fails to file its pleading before the trial court,
My lords.
subsequently in the appellate stage, they come with certain assertion of facts. Then which way those facts are to be accepted by the court?
But it cannot be accepted at the appellate stage.
Where is the law in this regard?
I'll
there
place
a
the
law?
law, my lords. It has to be, facts have to be placed at the court of first instance. Lordships, otherwise what would happen is I would in a given case, my lords, I would build my defense in appeal, not at the original stage. Issues of law, my lords, can be urged at this stage of appeal,
that
but
we
not
can
facts.
understand. We can understand by applying
I'll
but then the
My
thing is
lords,
that is there any law holding such arena wherein an appellate court is barred to take into consideration the facts,
fresh facts. Yes, my
fresh set
lords.
of facts, which are not.
Yes, my lords.
You
I
have
can place it before.
any ready-made decision on that?
My lords, I'm a little handicapped today because I'm in
Okay,
Delhi.
it's all
My
right.
lords can have it on Friday. I can
No, you can
place the-
just tell us to take it to the appellate with the grounds taken.
My lords, page 59 is the memo of appeal, my lords.
Page 59. There are overlapping. Which one is some numbers are cancelled? Some are. Mr. Thapa, you have not done.
Para
Not
29,
erased
21,
properly
my
those
lord.
page numbers. So there are 2 page numbers. Some are just cancelled by.
No, we are concerned with one page, my lord.
No, my lord is correct, my lords. There are 2 page numbers.
Yes.
I apologize.
Yes.
Page 59 it starts, my lords.
Yes.
And the grounds, my lords, will start from page 68 onwards, my lords, the grounds start.
Yes. Any ground taken on section 10?
My lords, they have taken that.
Ground number E, my lord.
Okay.
DE.
Okay.
If my lords kindly have a look at D, my lords, for the respondent had intention.
This ground
suppress
was
the
taken without
Uh,
filing any response in the trial court, isn't it?
trial court, my lords, or filing a fresh application seeking stay of that subsequent suit.
What is the prayer?
My lords would have a look at page 72. They ask for setting aside the order of 18/2/2019.
Okay, there is nothing about stay of suit, isn't it?
No, my lords. I'll take your lordships to the order of 18/2/2019, which was the subject matter of challenge that my lords would find at page 55.
You have any interim prayer here, Mr. Paul? In this case,
My lords, I will not press the interim. My lords may admit.
you
the
do one
revision
thing,
and-
Mr. Paul. Probably this
My
matter,
lords.
if you dispose
My
of
lords.
dispose it in one shot, that will be better. We'll list it for admission
My
here
lords.
and
My lords.
just take up it for disposal. I think that will be better.
My lords. That will be fair.
Exercise twice because
My
the
lords.
matter has to be decided more or less on the points of law, nothing else.
Lordships.
Okay. Hard. Mr. Paul Leonard, Senior Counsel, assisted by Mr. Thapa, Leonard Counsel appear for the petitioner, and also Mr. Karim, Leonard Counsel, appearing for respondents stroke cavator. Yes, sir. As agreed to by the learned counsel appearing for the parties, this is a matter for admission hearing on after
A week, my lords, if that is
a week will
convenient
it
to
be
my lords.
possible. After a week will it be possible.
My lords, may I pray then we have it immediately after the puja vacations?
That is better. Make it after 2 weeks. After 2 weeks, so that will take it after.
But highly obliged.
Daily list, item number 1.
May I please, Your Lordship? Your Lordship, notice upon the respondent number 2 had returned unserved, Your Lordship.
So what is to be done then?
Because we have taken steps upon the address which was
Address is
provided in
not
the
found.
complaint.
So what you'll do?
Ascertain the correct address, Your Lordship.
So you'll take fresh steps.
Yes, Your Lordship. I'll ascertain the address and I'll take fresh steps, Your Lordship.
That is what. Yes. The office note indicates that the notice upon the respondent number 2 was returned unserved, with a note that the addressee was not found. Stop. The petitioner shall verify the correct address of the respondent number 2 and take fresh steps for service for within how many days?
2 weeks, Your Lordship.
Within
We'll
for
take steps
verifying
within
the address and all will take 2 weeks time.
3 days, Your Lordship. 3 days.
Okay, within 1 week. Just make it within weeks because you have to verify the address and then you take it. First you verify the correct address, then you send it. Okay, otherwise it will be useless. You take steps again. You understand? Then just list this matter after 3 weeks. Take
Interim
step-
order may continue, Your Lordship.
Is there any interim order passed in?
In the miss case, Your Lordship.
Where is the miss case?
Miss case number 3, Your Lordship.
Okay, just say listed along with the main case. The interim order, if any passed earlier, shall continue till the next date. Yes, you are appealing for the state.
Yes, Your Lordship.
And this is a criminal petition. So what role this respondent number 2 has to play here?
It's a complainant, Your Lordship. He was the one who filed a complaint before the Lokayukta.
And then the state is what?
Just a formal party, Your Lordship.
State is a formal party. What is the nature of complaint here?
They are alleging that there's misappropriation of funds, Your Lordship.
Oh, this is against the Lokayukta.
Yes, against the Lokayukta
Say
order.
that simplifies the thing. Okay.
Item number 2.
Yes.
See, I am preparing for respondent number 3, Lordship. Private respondent.
Yes, you are supposed to take steps for not service of notice upon the respondent number 3.
Yes, Lordship. What
I
are
am
these?
doing it.
Okay, you will appear for the number 3. What is the matter about?
Your Lordship, this matter pertains to the questioning of the FIR, Lordship.
In relation to what happened?
ATM was lost, Lordship. The ATM was lost, Lordship, and
Okay, ATM card was lost.
Yes,
There is a
Lordship.
compromise.
yes, Lordship.
That is what your case is.
Yes,
okay,
Lordship.
we'll list it for hearing then. Yes, yes, I knew you were there.
I'm appealing for the statement.
Yes, just say Mr. Yes, the Sheikh, Learned Counsel has entered appearance on behalf of the respondent number 3. And hence service is complete. Yes, next paragraph is spread for the parties. This is matter for hearing after 2 weeks. We'll have it after just for the vacation.
Yes, Lordship. Much obliged.
Thank you.
Item number
You are not, Mr. Sheikh, you are not filing any objection or anything?
No, Lordship. You just support.
Yes, yes, that's all right.
Obliged, Lordship.
3.
Yes,
This is a case case of romantic relationship lordship because
You will appear. You are appearing for.
I am appearing for the respondent number 5 and 6 lordship.
First, you let us make your
Yes.
entry here. Then
Yes,
we'll.
lordship.
You will have a right to submit only after your entry is registered.
My lord, what happened, what I have seen the last order, my lord, because they are staying as husband and wife, that is why they could not take the estate, then they serve the copy to the complainant and the victim and they are communicated. That is why, lordship.
Now you are there. You will enter
Yes,
appearance.
yes, lordship.
And we will record your entries. You are not filing any objection here. Yes, Mr. Sangupta.
My lord, I'll be appearing for respondent number 1, 2, 3 and 4.
And what is the stand of the state?
My lord, the matter is pending, my lord. It appears, my lord, if it is having a romantic relationship, my lord, the outcome of the...
If it is serving like you do not know, it is for you to say. If you say it is.
My lord, they are yet to forward their main contentions, my lord. So,
Okay. We will just list it for hearing then.
We are in
Okay. They are also saying what to say. Mr. Singh enters appearance on the respondent 5 and 6.
5 and 6.
Service is complete as paid for the parties. We'll list it for hearing after 2 weeks. Yes.
Must.
Hearing item number 9.
May I please,
Yes.
Your Lordship? Your Lordship, I'll require to take instructions whether we'll still proceed with the matter or not, Your Lordship.
That is a case where you have made submission on the last occasion that you will file an application for withdrawal.
Yes, Your Lordship. So I'll just take instructions, Your Lordship.
Well, Learned Counsel appearing for the petitioner submits that fresh instruction is required from the petitioner as to whether the petitioner is still interested to pursue this case or not. Stop. The Learned Counsel therefore prays for grant of some time to have necessary instruction. Prayer allowed, list after 2 weeks. Yes. You are there? You want to say something?
No. This subsequent development is an order passed by the division bench.
So, what is the effect of that order here?
This matter will no longer
Survive.
I'll just take
When he will
instructions.
take instruction, let him take instruction. If he is not a, like a hardcore litigant, he might withdraw.
Please the orders.
Okay, well, on the next day you place it, be ready with this, and meanwhile let him also take instruction. Because that is a submission which was advanced by Mr.
Yes.
On the last occasion. Yes.
Great.
11.
Filed an affidavit to bring on record, my lord, the settlement agreement.
Okay. Where's the
Sen-
other side?
Mr. Sen is in the matter. I believe he's on legs. Have it
Someone
next
should be here. He has his associates, isn't it?
Yes, yes.
Can we make it a part of record and close the matter?
Yeah, we can do that,
Or
my
will,
lord.
will it be proper to in other? Yes.
Moin is here, my lord.
Have you filed an application? Oh, so,
I filed an affidavit, my lord. Served a
You
copy
filed?
to the other side.
and have you filed it?
No, I've already filed.
So we'll close this matter.
My lord.
Yes. In terms of the order dated. What was the last order? 1/9/2025. Is it a joint affidavit or it is affidavit filed?
I filed the affidavit. I've served a
the,
copy.
the petition.
yes, ma'am.
Yes. So an affidavit has been filed by the petitioner to bring on record the agreement dated
11th August 2025.
laying down the terms and condition of the settlement between the parties here. Stop. The next paragraph, the Learned Counsel appearing for the parties submit that since the matter has been settled amicably, the present petition. What is this petition? The criminal petition. This instant criminal petition may be closed in terms of the settlement dated, in terms of the agreement dated 11th August 2025. Have you written the date earlier in the while doing this? Stop. In view of the submission made, this matter stands closed as infructuous.
Ballot. Obligation.
13.
Malaj, in item 15, I am there.
Yes.
I was making a prayer. I'm making a prayer, Malaj, if my lords kindly take up this matter next week, Malaj.
Oh, that is Mr. That, yes.
That other matter, Malaj.
Yes, Mr. Paul. There, here, this court passed the interim order only on the basis of your assertion.
Malaj, I quite recollect, Malaj. I quite recollect. Which is why, Malaj, I am saying if my lords kindly take it up next week, we'll see, Malaj, what can
The
be.
court was under impression that you will use your influence to bring a settlement.
I have been. I've been trying, Malaj.
If you want, you can do it. You are
Malaj. I bow down, Malaj.
You are an able man.
Have it next week, but my lord, I have instructions that some FR has been filed. Now, whether it's a charge sheet or a final report, my lord, I am not sure. So let the matter come next week. When the matter was investigation was state, I don't think so FR should have been filed. But I have just got the information.
Not have been filed. Could not have been filed.
Would not have been filed. So, my lord, let it come next week, my lord. I have no objection. In the meantime, I'll also find out whether actually FIR has been filed or not. Because what I know, my lord, on the first occasion itself, the investigation was stayed. Now, if the investigation is stayed, there cannot be any further investigation. Investigation can either culminate into a charge sheet or a final report.
Definitely. And it is only the initiation of investigation which resulted the petitioner to approach this court. Isn't
Absolutely, my lord. So,
Close investigation within 2 days.
how is it possible?
Opening it after 2 years of
Absolutely,
filing.
my lord.
After 2 years, my lord,
Very,
in
very
concluding
suspicious.
That's what, my lord. I was also surprised.
Hope Mr. Paul doesn't have any role there.
My lord, I would be on the other side.
Just expect for the Learned Counsel appealing for the parties. This is matter after 1 week. Just see, Mr. Paul, if anything can be done.
My lord, I make an effort.
Obliged.
Okay. Interim order passed earlier. Shall continue.
May continue.
Obliged.
Yes.